The following program is suitable for general audience of any age.
Tonight, we discuss the salient features of legislation surrounding domestic violence in Sri Lanka. Have these laws adequately developed to keep with modern times, or are we lagging behind? A very good evening. You're joining us on Law, Land and Liberty here on Other Derana News Channel. Thank you very much for tuning in. We have yet another legal concept to break down for you today to make it easy to understand as a layman. And today's topic is something quite sensitive, and we have touched briefly with topics in the past as well in combination, but this is the first time we're actually approaching it as an act in itself, and that's on domestic violence and the legislature surrounding it. To speak about this, we have someone that's not a new face on the program and is very well equipped to actually guide us laymen through this the legal landscape that is around domestic violence, and that is Mr. Ian Fernando, attorney at law. Thank you so much for returning to the show, sir. Really glad to have you back. A little bit of an introduction to Mr. Fernando. He has close to 40 years of experience at the bar, and he does specialize in multiple areas as well as a focus in the civil practitioner's side. So we are in very good hands when it comes to this specific act as well. We've gone through an entire list of possible questions, and the way we're going to break it down for you is this. First, we'll be getting into the fundamentals of what the act essentially encapsulates. Next, we'll be going into the current context and what we can see as practical applications. And finally, we'll be talking about possible amendments and maybe future reforms that we can see popping up in this area of the law.
Hello, my name is Derana and I'm a student in St. Sebastian Balika Mahavidyalaya. My question is on the fundamentals. What are the salient features of the Domestic Violence Act?
And without much further ado, let's get right into this discussion. Thank you once again, Mr. Fernando. It's a great pleasure to have you back on the show. This time it's related to the previous topic that we spoke about as well, which is why I feel like it's adequate for us to maybe pick up where we left off almost.
I must tell you that I went through, before going through this topic of Act number 34 of 2005, the Domestic Violence Act. And I read this Indian book by Dr. Kumar Singh. In his preface, he has thanked his wife, who is also a doctorate in law, his son and his daughter-in-law. In the same way, I like to thank my daughter, Miss Roshanara Fernando, who is now working under me, for the immense guidance she has given and the research she has done on this topic.
Yes, it's great for the acknowledgement as well to understand that, the research that went into this program is not to be taken lightly. I want to get right into the discussion, Mr. Fernando, specifically relating to the fundamentals and the basics. When it comes to domestic violence in the public sphere, there's a lot of conversation about what it can mean to, what it can amount to. Can you just tell us specifically what actually amounts to domestic violence? What is domestic violence?
Yeah, domestic violence came into operation as far back as I think somewhere in the early 2000s, within the United Declaration of Human Rights, with CEDAW, that's an organization protecting women, formulated this on a Belgium platform at a particular conference where the rights of people on domestic violence will be protected. So thereafter, in Sri Lanka, we have this Act 34 of 2005, which 2005, which recurs to the Belgium Convention in setting out certain guidelines to protect people in domestic violence. And domestic violence means any violence between members of the family, husband and wife, or the children and the mother, and vice versa, or even the relations living in the house. But if it's a servant, for example, the servant has done something wrong, to make it more spicier, has not put enough chili powder in the curry, and you hit the servant with the chili bottle, that doesn't become domestic violence. The domestic violence is when you are related to each other, in the same household, if you're having even shared occupancy, there are violence between parties.
So it's correct for us to understand that the meaning of the word domestic in that sense has to include the filial ties and the familial bonds as well.
Of course.
And it's not just, I think it's very important that you mentioned that it's not just individuals under the same roof, but also having that
relationship
connection
with each other.
Yes, exactly. Now, I think it's important that you actually gave us a bit of an introduction as well relating to the act at hand when it comes to domestic violence. Can you run us through the salient features of this act?
Yeah, the Domestic Violence Act, if you do anything that is violence construed in the act, you can be charged criminally other than in the act. For example, if you assault a person, if it's simple or grievous hurt. If it's grievous hurt under section 312 of the Penal Code. If it's simple hurt under section 314 of the Penal Code. And Anuradhi, if you just point your finger and say, I'm going to hit you to your spouse even, that is considered assault. You don't have to physically hit that person. The fact that you raise your hand, that is why I said never raise your hand. If you raise your hand, that is supposed to be assault. So that comes under our Penal Code in section 344. So on those three grounds, if you do any act that can be termed to be of domestic violence, but also recently emotional, or you make things in such a way to make it impossible for the other person, that too is considered to be domestic violence. In Hanslow versus Yemshaw in 2011, 3 UK law reports in the Supreme Court, it was held that domestic violence is not only physical violence, it can be mental and emotional violence that you can set against a person.
So it's a whole range of possibilities. The scope of this act, as I understand from your explanation, is quite large. I want to run through the sections of this act as well, specifically relating to how exactly the Domestic Violence Act that's operating in Sri Lanka aims to protect victims that claim to have been subjected to violence of that nature. How exactly is the process when it comes to filing a complaint, or maybe going through the process of utilizing this act? What does it look like?
The act in section 2 spells out in detail the applicability of the act. So what is domestic violence is set out in also the act very clearly, and the act section 2 says that any person who has any act of domestic violence, who is aggrieved of such act, can go into court with an application. An application would normally be accompanied by an affidavit, so that you are swearing to court the facts of what took place, and that can be pursued personally or through the police. That application can be made to court. And according to section 3 of the act, the judge has to consider your application first. It can be ex parte, sometimes it can be inter parte. You have already called the party to court. Most often it becomes inter parte in this instance, because the other person is also notified at the police station that she would have to come to court, or he would have to come to court. Then after the application is tendered to court, court will determine whether an immediate interim order is going to be given to either party who is aggrieved. And that interim order stands only for 14 days. So on the strength of the affidavits, sometimes even counter affidavits can be given by the opposing side, representations must be made at length to court, and the court will obtain that there is an immediate emergency that an interim order be given to stop the violation of the Domestic Violence Act.
So moving from that point onwards as well, so when it comes to the remedies, now I understand that there is the initial beginnings of being able to utilize the act. You mentioned the application and then the consideration, potential interim order that's immediate, and then maybe on recalling or there could be a dissolution of that sort. A question of curiosity relating to interim orders in this aspect, sir. If there are reasonable grounds, I understand that an interim order will be provided by the courts. Are there any instances in your practical experience you have seen that interim orders are given on grounds that are not exactly considered as substantial as it should be?
Yes, Radhi, now, for example, the defense, when you are stating on that grounds, can show that this malicious act has not been done. It has not been done intentionally. If you have done any criminal act intentionally, then you are bound by that. So, if you can prove that it has not been done intentionally and see the reverse of the coin, of the story of the defense, the judge will sometimes consider the order given, the interim order for 14 days, be nullified in the first instance. But still, will go on to hear the case to see whether a final order can be made in terms of the Domestic Violence Act. So, at the first instance, when an order is given, sometimes with the objections files and the documents filed and subsequently even evidence being led, you can negate the situation of that protection order straight away to say that it should be removed. But that doesn't mean that it stops you from going to the final order, where you get a protection order for a period of 1 year. You are protected from either party who is trying to usurp your rights or come into your space, as they call it.
Right. And that leads me to my next question as well, because we want to understand better about the protections that are awarded to victims or maybe potential victims that have sought justice under this act. Can you tell us about exactly what remedies are available specifically, if we can have them listed out as stated in the act, maybe for us to understand better?
Yes, other than the protection order given for 14 days and other than the permanent order given for 1 year, Section 12 of the Act empowers that the court has a right to intervene and to see that someone's clothes are removed from a particular place, or that someone should get some financial assistance in that place, or someone should be sent for mental therapy and psychological treatment, family counseling. All those orders can be made supplementary to this protection order and the final order, which are auxiliary orders under Section 12 of the Act. That has a very wide scope. So, it's not only limited just to the two orders, the 14 days protection order and the final order. Court has a wide discretion under Section 12 to make any order he wants in terms of the law.
So the discretion of the court is quite a significant power that we see when it comes to considering this act.
Yes.
I want to ask you about the protection order as well, Section 10. Specifically relating to the details on that end. So you just mentioned about the other awarded legal remedies, but can we get a little bit deeper into the protection order that's
Yes,
mentioned?
the protection order can be protecting the aggrieved party from either spouse or family member from attending the house. Sometimes when I say house, the husband might be owning the house and the husband has done something ruthless which has made the wife go to court and get a protection order. So he's basically evicted from the house. He is not asked to come into the house for the next 14 days. He has to pull out his stuff.
Despite him being the legal homeowner.
In spite of him being the legal owner. That's why Section 12 empowers court to allow you to come and take your goods. So it can be that sometimes the husband the interim order may be made a final order. And for 1 year, he won't be able to go back to his own house. Either way, if it's a wife, the husband makes a complaint, the same thing can happen. So practically I have seen when situations of that nature arise and they can't see eye to eye, some of my clients have advised them to take an overseas job for 1 year and to agree to the protection order. Because after 1 year, the protection order nullifies itself. So that's the loophole in the law. What you would do is not to fight with either spouse. You would go overseas and do your job, or go to an area that you need not come back to your hometown, and you remain there till that 1 year is over. That's a way of getting out of a situation of a domestic violence protection order. There is another way. That is, if you can get the spouse who made that order or get the order in her or his favor, invite you back to the house, although the order is relevant, is presently in operation. So if you can prove that the husband invited the wife back, though the husband got an order against the wife not to come into the house, the husband himself has violated the court order and invited the wife back. That's the next loophole in the law where you can nullify the protection order. And the other is, if you are a schizophrenic, if you are, I would say in
Not
colloquial
mentally
words, nuts as they call it, you can say that at that point of time, you were not very mentally sound. And that is why you made those gestures or made those acts of violence. And on that, section 77 of the Penal Code allows us of unsound mind, because there is no mens rea or intention to commit a criminal act, you can be seen to not be enforced into the order.
Yes.
That's the next defense you can take.
Yes. Relating to that aspect, sir, now we understand that there are some areas where it can be played to a better advantage when it comes to managing the situation that comes about in enacting or in utilizing this act. I want to ask you specifically relating to the process of applying this act as well. We've actually just been going through the basics. Is this process related to applying for a protection order under the Domestic Violence Act lengthy? What does the protection order request look like? What does that process look like?
The protection order is done after both parties are heard and both affidavits are tendered. The court will decide whether protection order should be given. But in some instances, straight away, on the degree of the crime committed, the court will give a protection order henceforth. But in most instances, both parties are heard and the natural rules of justice are embodied, and the court will give an order. In the court giving an order, court will take into consideration if there are children, that the children will not be affected, that either spouse who is having that order, his workplace or business that he is doing maybe at home is not affected. This protection order doesn't go only to the house. Protection order, you can be protected from your child going to school, from the other party, from your workplace, stopping either spouse from entering your workplace. So it's a very wide area when you say getting a protection order, or not even sometimes overseas. I see in countries like Australia, you can't even give a telephone call to the other party. That is a violation of the protection order. They go to that degree. But in Sri Lanka, we have not come to that limit. Normally, a protection order sorts out the issue, like in the criminal court, we have that both parties are bound over. That was the earlier law. Both parties are bound over. If you do anything wrong thereafter, you will be taken into custody and charges will be framed you. So this is a similar thing in the Domestic Violence Act, which we have bound over in the criminal procedure, to stop each party from having any regular disturbances or violence with each other.
Yes, I want to continue this discussion specifically relating to other members of the same family and how exactly the Act responds to that as well. As you mentioned, there is a special consideration when it comes to children and their living situations also, and maybe we can get into, relatives that live under the same roof with that same connection. But before we get into any of those specifics, we do have to go in for a short commercial break. You're watching Law, Land and Liberty here on Other Derana News Channel. We'll be right back after this. Stay tuned.
Hello, My name is Visidika Vishwanarayanikanda and I'm a student in Yashodhara Vidyalaya, Colombo. So my question is on practicalities, how is the Act adequately applied in varying contexts?
Welcome back to Law, Land and Liberty here on Other Than a News channel. We're in conversation with Mr. Ian Fernando, attorney at law. So thank you so much for the previous segment. I believe we covered as much ground as we could when it comes to the foundational understanding of the Domestic Violence Act. So I want to move forward with this. Before we get into any of the specific practical applications of this Act, I want to ask you about who exactly is awarded protection under an Act such as the Domestic Violence Act. Now, we have come to understand that it should be with those that have familial relations under one roof. But what are the criteria? Is it relatives that are able to apply? Is it only spouses? What's that looking like, sir?
Not only spouses, children of the half-blood, relatives in the same building, people who are having shared occupancy, and even those who are living together. You don't have to be related by marriage or by repute or whatever. If you are living together, which is now considered to be the olden day system of cohabiting each other. So if you are living together and you are not married, also if there is violence done to you, Domestic Violence Act plays. And if you are done by humiliation and mental agony, financial agony is something that is yet to be seen, the financial agony part of it. In our country, we don't have that. But mental agony and humiliation is set out that we can come under the wings of the domestic violence.
So that means it doesn't have to be just between a husband and wife.
No.
or that kind of situation.
No.
It can be for a wide range of scenarios. You just touched on a very important point, sir, relating to the duress that the victim would have to have gone under in order to qualify to apply for justice under this Act. As you mentioned, financial agony or emotional agony. Can you go through some of the areas that could be listed in this Act?
Yes or no? If you take, for example, some financial agony, if your spouse says that she will look after the electricity bill, now in today's context, both husband and wife are always working. And in order to give you more a financial burden, stops paying your electricity bill for about 3 or 4 months. The electricity department will cut your electricity. Then there is a dispute there which is caused between two parties. And that's done deliberately because there is some drift between the parties. So there you show a financial agony where domestic violence is done. Still we have not seen that development of the law in Sri Lanka, but the textbooks that I mentioned earlier, Dr. Kumar, Pramod Singh Kumar, has specifically mentioned that area. And also the humiliation. For examples, you are taken all over the place for functions, parties, dancers, film shows, and you keep humiliating your partner or your spouse or your person whom you are living together, that also you are intruding into that particular person's space. There is a space between two parties. So when you override that space, that too can be considered to be domestic violence. Still in our courts, though the provision is set out under section 23 of this Act, which denotes what is domestic violence, these areas are up and coming areas where will be considered in future in the advancement of the Domestic Violence Act.
I want to continue on the note that we left off on in the previous segment, sir, relating to now that we have an understanding of what exactly comes under domestic violence per se for this Act. I want to ask you, sir, relating to now protection orders that have been already issued. Since this is considering a domestic context as well, there could be withdrawals, there could be changes in situations. What happens when a protection order there's a revocation of a protection order, or maybe it doesn't go through? What happens in that context?
When there's a revocation of the protection order, the case doesn't fall. Because if it's an interim order and the revocation is done, still, as I mentioned earlier, you can go up to the final order. So even if you fail at the interim order stage, maybe you have more evidence to prove at the final order stage, and you need to be protected from either spouse in the school area, your workplace, or your home. And any other area also can be specified according to submissions you make. So that is the development that we are seeking in future, not only those three main areas, there may be other areas also which the court has discussion to debar you from entering to stop any domestic violence.
Yes, I want to get to those areas that we can expect reforms and amendments and maybe changes in further down the line. But I think to help us understand and get the gist of the repercussions of having, are not undergone, but being a perpetrator of domestic violence in a setting, specifically when it comes to the penalties aspect that's listed under this legislation. Can you tell us, sir, relating to what penalties are listed under the Domestic Violence Act in Sri Lanka, and maybe a little bit about what we can expect as maybe actual imprisonment terms, or is it only the 1 year that we mentioned previously? What kind of penalties are existent, sir?
Anuradhi, before we get into the penalties, we'll get into the area where summons is served from you through court and you don't come to court. Then the normal criminal procedure will take place. And you can get an order to come and paste it or to serve it through the Gram Sevakya. And still so, if you don't come to court, in the criminal procedure there are provisions where you can arrest you and bring you to court. If the police are not producing you and you don't want to come, you can get under our criminal procedure code, you'll be arrested and produced to court. Then the protection order is made and you violate the protection order. Then the act specifically sets out the redress that the other party can get. That is, you will be imprisoned for 1 year, rigorous imprisonment for 1 year, and you will be given a fine of 10,000 rupees. So that is set out in the act for any person who violates the act, or you will have both, that is imprisonment for 1 year and also the financial fine. So that will give recourse to people not endeavoring to do any domestic violence.
So there is a bit of maybe consideration when it comes to future offences as well. As you mentioned, sir, previously, it's not a one-off issue. The Act tries to solve any future implications as well. Do you believe that the current structure of the Act allows for a better maybe outlook when it comes to perpetrators that have once committed an issue, and then there's maybe a little bit of a reluctance to commit that same issue? Do you think that the Act adequately encapsulates that, or are we not really seeing as much of a strength than it should be?
As you use the word encapsulate, it doesn't, because it's only for 1 year. As I mentioned, I have advised so many clients to go overseas. So when they come back again to their house, they will start the same issue again. So the Act basically should be necessarily every 1 year it can be reviewed. That word reviewed can come into take place. And if the judge is of the opinion that this person is abroad, but then he has not done any domestic violence, when he comes again, he might do the same. So when you put the words reviewed, the judge can give a protection order for 1 year and then review it again and give another protection order for 1 year if this chap will come or the other spouse will come and create havoc in the domestic area of his matrimonial house, creating domestic violence.
So there's a bit of a confusion as well when it comes to the handling of domestic violence cases in the country, not just specifically under this Act, but also through judicial officers and also the individuals that are responsible for handling these cases. Do you believe that police and judicial officers right now are adequately equipped when it comes to handling these kind of sensitive cases?
Yes, they need to be trained, and the Act especially provides in a particular section that the family counselors, probation officers, and people who are affiliated with the court procedure, that they be trained, because you need to have the psychological impact on this matter. Even psychiatrists may get involved. That's the area that the government of Sri Lanka can think to enhance this Act, where they are put to psychiatric treatment, not only mental counseling, and seen what has gone wrong. For example, I had a case where a fishmonger used to meet his wife in the night, and the wife never allowed him to sleep with her. At the police station, it was revealed what was the story behind it. The story was that he used to come from his fish shop smelling of fish. So that caused the domestic violence. That is why she wouldn't sleep with him. So that was sorted out. And then they were back together. So there is amount of counseling that has got to go through to find out why this domestic violence took place. Unless you come under Section 77 where you're a lunatic or you are under influence of drugs or drunk, how this came into existence. This small thing will erupt into domestic violence, a small issue, if you don't nip it in the bud. So basically, we should be thinking of psychiatric treatment, counseling, which also provides counseling in the Act, but not psychiatric treatment, to stop this type of domestic violence being escalated in Sri Lanka.
Exactly. And now when it comes to, we do have to talk about the future aspects as well, but before we do, when it comes to the process of considering a protection order by the judicial officers or the court in itself, can you tell us about the necessary evidence? Now, we need to understand what grounds constitute an adequate, approval of a protection order from court. What kind of grounds of evidence is looked into in that sense? Is it just a statement? Is there physical evidence? What kind of evidence, sir?
Basically, physical assault, which amounts to simple hurt and grievous hurt, will be what the judge will look into at the very outset, and to see that they are not incapable or incapable of staying with each other together for a considerable period of time. That age-old saying goes, absence makes the heart go fonder. So the judge basically is giving you 14 days away to brief from your spouse to see how you are going to fare. And your spouse in return, if she or he invites you, is also breaking that order. And then you can get it nullified. If you put it for 1 year, the saying absence makes the heart go fonder may be more recognized, because by that time parties will realize, come to earth and sort their problems out for the sake of the children.
That is a question I wanted to ask you specifically as well, relating to children in such a situation, domestic violence. We understand that is where the impact most probably lies the most. How exactly does this Act address that kind of scenario? I understand from your previous responses as well, so that there is some sort of sensitivity given to that kind of case. What does it look like?
The Act doesn't provide a provision where either party instigates the children against the other spouse. There is another loophole in that area. Whereas domestic violence can take place not between the two parties, but either spouse can initiate that domestic violence by telling that child, don't go with either spouse, don't go with your father, or the mother says, come only with me and no one else. Then that child has only one type of parental care. The mother's parental care alone is not enough. You have to have the father's parental care if it's in the case of a son. So, in that scenario, I think there should be some development where one spouse can't intimidate young children under 18 to do certain acts. The law provides that after 16 years, you are somewhat reasonable, attuned to the legal procedure, but you can give evidence basically only when you are around 18 or plus. Not that they will not consider between 16 and 18, but that's the time you go to realize. That is why we do our advanced level at 18, not at 16. So when you come to the advanced level, the children can then decide whether they have been utilized in this matrimonial or living together or whatever in the same, under the same roof, that they have been utilized which causes the domestic violence. Now, in that way, we don't have any provision in our Act, which is to be, I think,
maybe we can get into that in the next segment, because we have come to time in this segment. We have to talk about that specific aspect, the improvements that we can expect, and also the amendments to the future of this Act, and what we can expect to see as a change in the landscape when it comes to domestic violence and its addressing in court settings as well. So let's take a very short commercial break. You're watching Law, Land and Liberty. We'll be right back after this. Stay tuned.
Hello, my name is Himandya Sidney and I am a student in Gautam Balika Vidyalaya, Colombo. So my question is, on the future, what can we expect to see as reforms or amendment to the legislation?
Welcome back to Law, Land and Liberty. We're in our final segment in conversation with Mr. Ian Fernando, attorney at law. So thank you very much for the previous segment. We were just done discussing about some of the fundamental areas of the Domestic Violence Act in Sri Lanka. And before we get to the key focus of this segment, which should be about reforms and amendments, there is a specific question that we weren't able to touch on in the previous segment, and that's on the appeals process. Can you tell us about the section that actually helps us understand what the appeal process looks like for orders placed under the Domestic Violence Act?
before we Anuradhi come to the appeal process, when you are facing a domestic violence charge, there must be a specific charge against you according to our criminal procedure. Without a charge, you cannot go ahead. So once the charge is levied and then you have given your defense, and if you are aggrieved by the said order, you can appeal to the High Court of High Court in the particular area. But practically, we don't see that happening, because the domestic violence case takes about 6 to 8 months in the same court itself, and the chance to appeal within that 1 year, if you go up in appeal, for examples on an interim order, the appeal might take a little longer than the original court procedure. So we have very few case laws or very few judgments to go through to advise the public on that, because hardly any, because they hardly go up in appeal. They get sorted out somewhere. But there is a right of appeal under Section 17 of the Act, where you are allowed under your Domestic Violence Act 34 of 2005 for you to appeal. That is namesake there. But the normal practicality, being a practicing lawyer, I see, is that it's resolved in the lower court. Sometimes there are consenting orders that can be made according to the Act. There's provision in the Act for consenting orders where both parties agree that each one will not trample each one's foot or feet for the next 14 days or for the next 1 year. Then the matter resolved then and there. So basically, it is a binding order of, as you say, where both parties are bounded to stop each other from fighting or committing domestic violence.
Yes, and as I understand, this Act serves a fairly well representation of how exactly to go about that. But I want to ask you, sir, when it comes to the effectiveness of this Act, we were hinting at it from the beginning of this program as well, about what can be done to better optimize this Act that we have in practice in Sri Lanka. With your practical experience, there are certain areas or lapses in this legislature without a doubt. How exactly can one go about with addressing this? What reforms do you think we can expect to see moving forward, and also maybe amendments?
With the research done by Ms. Roshana Fernando, my daughter, I came to understand that in the Act, where people are reluctant to come forward because of their background to say a domestic violence act took place. So, like we do in some divorce cases, we can ask that it be heard in camera. That provision also I don't see in the Domestic Violence Act, where if you are hearing this case, you are heard in camera, where no one knows except the court staff and the court pudli and the to opposing counsel, where it's a private matter. If there has been a slap given from you to your wife, that's a private matter. That's not to be a public matter. And a slap is not going to be of a great nature, of a simple hurt or grievous hurt. It's an assault, no doubt, under section 344. But that's a matter that can be resolved. So if we give a situation which arises that some sensitive cases can be heard in camera, I'm sure more domestic violence cases will be predominant in Sri Lanka.
That's also one of the areas that we want to see, specifically when it comes to the current context, especially with social media and everything that has been coming into development. Is it possible to understand whether the addressing of domestic violence, or maybe the acceptance of actually acknowledging domestic violence, is that climate conducive at the moment, sir, according to your experience?
It's climate conducive, but you cannot do any publication regarding that. Those matters are not to be publicized. According to the Act, there is provision, I believe, that those are not to be publicized. So as soon as you stop that happening and you hear cases in camera where quick disposal is given, like, we have mediation boards for small problems where under 500,000 rupees, if there is money due or owing, you have mediation board. You can have some sort of a mediator in the Domestic Violence Act who does the counseling part and tries to see whether it can be stopped before going into court, immediately, not to wait for the 14 days. You have provided a family counselor who, on acting on an issue where a complaint is made to the police will get in touch with the family counselor straight away, and there will be a legal framework how she has to or he has to act and resolve the matter before they go into court. So the matter can be sorted out at home. You don't have to go to the domestic violence court to sort out your slap. The matter can be resolved, like some matters are resolved at the police station, can be resolved under a counselor who is equipped in psychology to understand the problem and give quick results.
Exactly. That is a potential feature that we can expect for quick relief. After all, these legislature do not act or do not exist just to prove a point, but rather to provide relief to the aggrieved parties. Unfortunately, that is all the time we have to discuss this specific act with us here today. Thank you so much, sir, for the time that you took to come to the studio here today. All right, well, we leave you tonight with the words of former Prime Minister of the UK, Theresa May. Domestic abuse blights lives. It can destroy lives, and not just the life of the immediate victim, but of the children and other family members as well. That's all we have for you tonight. You can rewatch by catching us on our YouTube page, and we value your opinion. So please share your thoughts and feedback with us through email at feedback.adncenglish@derana.lk or via WhatsApp at 076 805 7933. Thank you very much for watching. Have a great night.